Myself, Dr. Supinder Kaur. I am professor at Department of Laws, Punjab University, Chandigarh. Today I am speaking on the topic that is from the subject of law. The name of the topic is Hindu women's right to property under law as well as under society. Now, this topic I am discussing here at Jagat Guru Nanak Dev Punjab State Open University, Patiala. As a part of the topic has to be bifurcated under a few, I would say, heads or under few categories, wherein we need to know that when and how this right to property to be attained by a Hindu woman had came in discussion. If we look into the history or we go way back in the study of personal law, since this topic is a subject of personal law, that is family law, more specifically Hindu law, where a Hindu woman, how she would obtain a right in the property which she is obtaining either from her father or from her ancestors or from her husband, how she would be able to get a right, a concrete right in that property. The discussion, it belongs way back to the time period of Smritis, wherein there came there was emergence of two of the schools by the name of Mitakshara and Dhyabhaga. It was Mitakshara school of law wherein there was a discussion or some public opinion, I would say, at that very spur of time was taken that how the property which has been obtained, earned by a Hindu family, by the members of a Hindu family, how that property can be inherited or how that property can be retained. So for evolving the method of retaining the property, here came a concept that the property shall be carried jointly by all those Hindu males who are earning this property since the generations. So it became a generational property. It was also known as an ancestral property. It was also named as kopasnari in coming times, wherein the kopasnari was restricted up to 4 generations. Wherever it was, a concept emerged that any male who was born within these 4 generations, a son, grandson, great-grandson, that male can obtain 2 kinds of rights in the ancestral property. One, right by birth in the property, and other is right to ask for partition in that property, in that ancestral property. So this was, the property was carried as joint in possession and joint in ownership. And when any Hindu male was asking for partition in that property, the property was partitioned, divided among all the kopasners who were able to make their position in the 4 generations in a kopasnari. So only males, they were given the right to ask for partition. So here came the discussion that how far the females, Hindu females, are related to this kopasnari, because in a Hindu family, there was naturally a possibility of having females as well. Females as mothers, females as grandmothers, females as wives, females as widows, females as sisters, females as daughters. In either position, there were many female members as well in a Hindu joint family, in a Hindu kopasnari, to whom here came a discussion that how they will be attaining a share in that property, whether they are attaining a share in that property or they are not attaining a share in that property. So the discussion comes in a long sequence through the lens of law. When we look into this concept of inheritance, the inheritance means right in the property which is inherited, where a Hindu female was deprived since time immemorial, since she was not made a kopasnar in the ancestral property. So herein, when this partition was suggested as a concrete share to every male kopasnar Hindu, there at the time of partition, the rules were fixed. Rules of partition were fixed, wherein one rule, a customary rule, was settled that a Hindu female who is the mother of the head, the karta, who is the grandmother, who is the wife of the karta, these 3 females shall be entitled to get a share. They are not designated as kopasnars, but they were given a right to ask for a share in the kopasnari partition, ancestral property partition, and if they were not given a share in the partition, they were given the right to seek that share by filing a suit in the court. So 3 females, by custom, they were given a right by love and affection from the ancestral property. Now the rest of the females in the kopasnari, they were the daughter-in-laws, the daughters specifically, then the widows, the karta's widow, son's widow, grandson's widow, great-grandson's widow. No, they were deprived of getting any share in the kopasnari property directly. But there was a custom wherein a Hindu widow, the son's widow, grandson's widow, she was given a right to ask for a share in the Kopasnari property of her deceased Hindu husband. Meaning thereby is, when he was dying without taking any share in his ancestral property, now in his share, the widow, his widow was given a right to put her step in the shoe of the Kopasner, this dying Kopasner, dead Kopasner, and she was obtaining that share that was to be given to her husband if he was alive. Otherwise, that share was going by survivorship to the other Hindu brothers, Hindu Kopasners in parallel line of that deceased Kopasner. When we discuss the position of a daughter in that Kopasnari, the daughters were not given any direct right to ask for share in the partition. Neither they were given any share out of love and affection. Rather, there was a power given to Karta, the head of the Kopasnari. Either he was a father, grandfather or great-grandfather, that he was by custom able to gift some property of movable nature to the daughters, granddaughters, great-granddaughters at the time of their marriage or subsequently to the marriage. That was a custom. But after there's a Supreme Court where this right of the Karta was discussed in Guramma versus Malappa's judgment in the year of 1958 Supreme Court. Now there came a discussion that when it comes to gifting a property from the ancestral property of the father, whether the daughters are entitled to get only movable property, there it was decided that even a small portion of immovable property can be given to the daughter by the Karta. The Karta, again I repeat, it can be the father who is Karta, grandfather, great-grandfather at the time of the marriage of the daughters, granddaughters, great-granddaughters, or subsequently to the marriage. A small portion of immovable property can also be attached with the movable property. So what I mean to say is that a daughter was able to get something on the name of gift from the ancestral property of her father. Now, this ancestral property is a custom till date. It is known by Mitaksha school of law. There is no codification done to devolution of property in the ancestral nature. So it is still governed by the custom. So custom always try to deny any share or right to the daughters or to the other Hindu females in the property, except these few exceptions were there. Now in the year of 1937, here came a legislation by the name of Hindu Women's Right to Property Act of 1937, wherein this widow, to whom by custom was given a right that she can put her step in the shoe of her deceased Kopasner husband and she can obtain her share after his death. Now that share was given to her not in an absolute manner. Rather, it was her partial estate. It was restricted estate. After the death of the husband, when she was obtaining that share she was able to live during her lifetime. But after her death, the share was coming back to the Kopasnari of the husband only. And this widow was the one who was a widow with a son. The Kopasner died, leaving behind a widow and her son. That was a custom. Now this custom was somewhere discussed in this Hindu Women's Right to Property Act of 1937. Though the name of the act suggests that as if it belongs to every Hindu woman. But the objective of the act was to give a concrete right to the Hindu widow. A Hindu widow in the same manner whereby custom she was getting a share when she was having a son. Now this law made it clear that a Hindu widow with son, without son, she is able to succeed a share in Kopasnari property from the share of her deceased husband when her husband died without taking any share. So somewhere custom and law combinedly, I would say, preferred to give a right to a Hindu widow, a Hindu woman who was a widow, to get a share somewhere in the ancestral property of her husband. So there was an intermingling or inter-application of custom at some places, and then at some places the law. The basic thing or basic discussion came concretely when under Hindu Code Bill of 1948, there came a discussion to codify the personal laws of Hindus. In the personal laws of Hindus, the codification came on marriages, Hindu marriages, by the way of Hindu Marriage Act 1955, by the way of Hindu Succession Act 1956, by the way of Hindu Minority and Guardianship of 1956, and the Hindu Adoption and Maintenance Act of 1956. So, in 1956, along with these four legislations, one specific legislation which was named as Hindu Succession Act 1956. So it was the year of 1956 wherein this coparcenary property, before 1956, every kind of a property, movable, immovable, tangible, intangible, earned by one coparcener, by many coparceners, gifted property or any other nature of property, it was clubbed as ancestral property and it was devolving by the way of partition. And in partition, the female Hindus, they were not entitled to get a share except out of love and affection, or except by the way of gift. So herein, in 1956 law, Hindu Succession Act 1956, the legislature attempted twofold objectives. One was to actually segregate this nature of property, that every property cannot be recognized as ancestral only. There are certain properties which are of separate nature as well. So the property is now either, before 1956 also, the property was classified as coparcenary and as separate, but since there was a mode of devolution attached with coparcenary property, that was partition, but there was no mode of devolution attached with the separate property. So the separate property against which there was no mode of devolution, that was also clubbed in the coparcenary and it was going by the way of partition to all the coparceners, Hindu males specifically. So in 1956, here came a concrete legal classification that when the property is of the nature of ancestral property, it shall go by the way of partition only, which is a custom, still a custom. But when the nature of the property is separate property or self-acquired property, then that property shall go by the way of succession. So ancestral and separate property, coparcenary and separate property, meaning thereby is coparcenary is which has a nexus with the ancestors. Separate is the one which is not connected to, not having any nexus to the coparcenary, that is ancestors, rather it has been self-earned. It is self-acquired, it has been earned. You can take the example, it is some remunerations paid to you, it is some salary attached with you, it is something which has been earned specifically by yourself with your earnings. Now that was a separate property. That doesn't mean before 1956 this property was not existing. It was there, but since there was no mode of devolution attached to it, so it was merging with the coparcenary and going by the way of partition only. That was the good reason why the coparcenary is a never-ending concept. So in 1956, a mode of devolution was attached to the separate property. Now this separate property, it was enacted by the law of 1956 that separate property shall go by the way of succession. Now succession means either intestate succession or by testamentary succession. Testamentary succession means a will. When he or she, they are dying without any partition or without any will in their property, her or his property shall go by the way of succession, that is known as intestate succession, to which this Act of 1956 belongs to. Testamentary succession means that everyone, he or she, is by law is able to make a will of his or her separate property. So a will belongs to a separate property. If he or she, Hindu, male or female, dies without making any will in that property, in her or his separate property, then that property shall go by the way of intestate succession. And this act, second objective of the act was that there is intestate succession with reference to the property of a Hindu male and with the property of the Hindu female. The rules were mentioned in this law itself. When we read the bare provisions of Hindu Succession Act 1956, you will get to know that all these provisions of Section 6, Section 8, Section 9, 10 and 11, 12, 13, they belong to the succession with reference to property of a Hindu male, separate property of a Hindu male. And Section 14, 15, 16, these are the provisions which describe the rules regarding succession, intestate succession to the property of a Hindu female. Now this property of a Hindu female, which is a subject we are discussing today. Now this property of Hindu female, now this Hindu female because of shastras, because of traditions, because of customs, she was able to receive this property to her. Either she is earning because she is working, that is totally, entirely, absolutely her separate property, or she is receiving that property either by the way of gift at the time of her marriage, or stridhan, that is dowry property which we say usually, or it has been gifted to her by her father, by her brother, by her husband, by her father-in-law, by any person at the time of marriage or subsequently to the marriage. That property had been given a status of separate property. And section 14 of this very law, Hindu Succession Act 1956, was very clear on the point that now her separate property will go by the way of succession, meaning thereby is the property shall be inherited after her death by her heirs, or by the heirs. Her heirs means her sons and daughters, or sons and daughters of deceased sons and daughters, her husband. If they are not alive, not available, then the property shall go to the heirs of the husband. If there is no heirs of the husband, property shall go to her father and mother. If they are not alive, the property shall go to the heirs of father. And if they are not alive, then property shall go to the state. That is known as the doctrine of escheat. Now, this law came with reference to, strictly with reference to property which is of separate nature and belonging to a Hindu female in either form of Hindu female, a daughter, a wife, a daughter-in-law, a widow, etc. That was separate property. Now, in 2005, a major amendment came in Hindu Succession Amendment Act of 2005, wherein a daughter, a Hindu daughter, was also included as a co-partner equal to her brother in the co-partnery property of her father, grandfather, great-grandfather. She was given a position equal to the sons. So, for a change, it was only Hindu daughter, granddaughter, great-granddaughter, paternal. It was a new section 6. The old section 6 of Hindu Succession Act 1956 was deleted and a new provision was substituted in Hindu Succession Act 1956. That was a landmark change which came in the year of 2005, wherein the daughters were given a right in the ancestral property of her father, grandfather and great-grandfather equal to the sons, grandsons and great-grandsons paternal. Now, this advancement in the co-partnery, it created a hue and cry in the legal and social strata, wherein they said the opinions were coming from the public at large that the very gist of co-partnery has been ruined by including a daughter. Earlier, why daughters were deprived to get a share in the ancestral property? Because co-partnery property was treated as a religion to the Hindus. So for them, a daughter is either, a woman, Hindu woman, is either coming from outside or she has to go outside by marriage. So their property shall not go in the hands of any other family. So that very concept, religious concept, was, I would say, vanished by this amendment, wherein the daughters, a daughter, married, unmarried, widow, divorcee, every kind of a daughter, granddaughter, great-granddaughter was given a right in the ancestral property of her father, grandfather, great-grandfather, with certain conditions and exceptions imposed. Because the amendment came on 9 September 2005. So, the section 6, when we read barely, it says on and from the date of commencement of amendment of 9 September 2005, a Hindu daughter shall be included as a co-partner in the co-partnery of her father. So, the provision was very clear that the amendment is applicable prospectively. It means from 9 September 2005, every daughter, that doesn't mean the daughter who borns after 9 September 2005. It means every daughter existing who was born even before 9 September 2005, it was every daughter who has been given this right to be the part of the co-partnery equal to the sons, grandsons and great-grandsons. So, this main clause was further added with the proviso, which said that any alienation or any partition which had already taken place in the ancestral property before 9 September 2005, the daughter shall not challenge that alienation, that transfer of the property, because at that time daughter was not included as a co-partner. Now, this daughter's right in property started from that very era. It was a date 20th December 2004 when the bill with reference to daughter's right came in discussion. So, it was already fixed in the minds of the society at large and legal scientists that the daughter very soon shall be included as a co-partner legally in the co-partnery property. So this 20th December 2004, when this bill was introduced, now the co-partneries, they very sharply, cleverly, they started partitioning their property with the objective that neither there shall be remaining any ancestral property, nor the daughters would be able to ask for a share in the ancestral property. Ancestral property nahi hogi, so there will be no partition asked by them. So within time period of 20th December 2004 to 9 September 2005, many partitions took place. So when this law came on 9 September 2005, when law said on and from the date of commencement of amendment of 2005, a daughter shall be included as a co-partner, it gave a very good reason, as if now from 9 September 2005 onwards only, she can ask for a share in the co-partnery property. When this proviso was added with the main clause, it made it clear that any partition which took place from 20th December 2004 to 9 September 2005. Now, in these partitions, she had been given a right to ask for partition as the bill was pending during that very time period. So, she has been given a partial retrospective effect to the amendment of 2005. Along with that, exception was added that any partition which took place before 20th December 2004, any partition which took place before 20th December, to that partition a daughter cannot seek for any kind of challenge. She cannot challenge those partitions. So no absolute retrospective effect was given. Now this clause 1 of section 6 was to be read with clause 5 of section 6 of Hindu Succession Amendment Act of 2005, wherein clause 5 said that any partition which took place before 20th December 2004, against that partition, if there was no registration or no legal document available, then that partition can also be opened by the daughter after becoming co-partner in the co-partnery property. Now it gave a conflict in the right of daughter to ask for partition or not to ask for partition. Now this debate, it went long till September 2020, wherein in the last judgment of 2020, that is Rakesh Sharma versus Vinita Sharma, wherein the Honorable Supreme Court held that the daughter who becomes a co-partner on 9 September 2005, she has been given a right, absolutely retrospective, to seek for partition in the co-partnery property. The debate started from 2005 and it is still remained in discussion whether she should be given an absolute retrospective right in the co-partnery ancestral property of her father, grandfather, great-grandfather, or this amendment is absolutely prospective in nature. Now in this domain, many judgments came in the discussion in the premises of the Honorable Supreme Court, wherein the discussion started in the year of 2013 in case of Prakash and others versus Phulvati and others, wherein the Honorable Supreme Court, by taking into account all the theories of interpretation of statutes and many other relevant examples from the history of the precedences, came to the conclusion that only a daughter of a co-partner can become a co-partner and can obtain a share in the co-partnery property as a Hindu woman. It is not every daughter, which means every daughter means like the one whose father was not a co-partner in the co-partnery, who was not running a co-partnery, that daughter cannot obtain any share in the co-partnery property. So because the very application of this amendment is prospective in nature, not retrospective in nature. Now that judgment became a landmark judgment, but which was not, I would say, suitable to the social and legal fraternity. So the judgment was challenged in another case which came after Phulvati's case. The name of the case was Dhanamma and others versus Amar and others, wherein this Phulvati's case was overruled and she was given an absolute retrospective effect to the amendment, and to her the right was given retrospectively again, which further criticized, and another judgment came in that reference, that was Mangamal versus T.B. Raju, wherein the Honorable Supreme Court again reinstated the judgment of Phulvati. and which again further came in discussion in Rakesh Sharma versus Vinita Sharma in 2020, wherein the entire efforts were done again in the premises of Supreme Court to discuss about whether the amendment of 2005 with reference to daughters' right in compulsory property, Hindu daughters' right in compulsory property, is of prospective nature or of retrospective nature. Now, the conclusion to the judgment was given in a way that it is of retroactive nature. Meaning thereby, the Honorable Supreme Court held in this very case that the amendment of 2005 is of retroactive nature, which means the phases the instances which are favorable to the daughter by law, they shall be included to give her the benefit. But that is not end of the discussion. It comes again in discussion again and again whether by her inclusion in the compulsory property, the nature of compulsory is ruined, or when she will be obtaining this share in the compulsory property, how that further share will devolve. Now, for devolution of her share, again section 6 has made it very clear that any partition share which is obtained by her or him in the compulsory property shall further go by the way of succession if she dies without making a will. That will go by the way of intestate succession. Even here came replacement of notional partition by deemed partition. The notional partition was a concept in the previous non-amended law before 2005, wherein the daughters were given a share by the way of notional partition, which is again a full-fledged topic. And this notional partition has been replaced by deemed partition in the amended law of 2005, wherein the concept is very clear, where she, a daughter, or he, a son in the compulsory, dies without taking a share in their respective compulsory properties, then their share will go by the way of succession, not by the way of partition. To that very branch, there shall be the rules of intestate succession which will be followed, not the rules of partition are going to follow. Now, which has been mistook as if the compulsory is ended. It is not end of the compulsory. Still, any share which is obtained by a son from the compulsory property in the possession of her son, that share becomes a compulsory only. But when it comes to daughter, when daughter obtained this share by compulsory properties partition, it becomes her separate property. Her sons and daughters are not able to be the shareholders in the partition of her father's compulsory. It is only paternal daughters, granddaughters and great-granddaughters to whom the right has been given. Now, this discussion it is an endless discussion. I have touched upon just few instances without elaborating the backgrounds of every instance here. But the topic is still open for the discussion, because again at present the discussion with reference to application as prospective or retrospective is still on. Secondly, the daughter when obtaining a share, it is merely a daughter to whom the share has been given in the compulsory property. Even a widow has been given a share in the compulsory property of her deceased husband, which somewhere gave a confusion that when she was included as a compulsory in 2005, it was taken as an impression as if she is now doubly privileged. The Hindu female, she will be getting a share from the ancestral property of her father as well as from the ancestral property of her husband, which was altogether a false myth or false notion. Legally, it was her, a daughter only. A wife is able to obtain a share from her husband's property only when her husband dies. Even if the husband, before death makes a will of her separate property and does not give any share to the wife, she cannot challenge that will. But if the husband dies without making a will, then as class 1 here, the widow is able to get a share in the succession, that is in the separate property of the husband. Similarly, in the compulsory property of the husband, when he dies without making a will or dies without taking a share, to that branch earlier there was a notional partition before 2005, now there is deemed partition. Now, how we conclude the topic, that even in the presence of this gender equality, the constitution which talks about gender equality by article 15 much way back, Now, still when it comes to the division of property, this equality is not prevailing at all, because on this equality there are some restrictions which cannot be said to be reasonable as well, but some exceptions, provisos, some judgments, some opinions, some debates, they are still restricting a Hindu woman to take an absolute right in either the ancestral property or in the separate property of her relatives. So that is a smaller brief discussion on a Hindu woman's right to property under laws as well as under society. Thank you so much.